Good afternoon, everybody. Welcome to our webinar. I'm Emma Tunley, a Policy Manager at the SRA, and I'll be hosting the webinar alongside my colleague Liz Bond from our FI team. Today, we're going to be talking about the SRA's duty to identify and set an appropriate fee restriction in financial mis-selling work. We published our discussion paper last month, and I'm sure you will have seen the FCA proposals for the firms it regulates published earlier in the year. More on that later. We've already received a number of questions in advance, so thank you for that, and we will be considering some of these later on. However, please do feel free to submit live questions by clicking the question link below this video stream. Before we get started, I just wanted to make you aware the webinar will be available on Catch Up along with the slides and links to relevant web pages on the resources page for this event. So, to start the webinar. So why have we published the discussion paper? Its focus is on a new duty on their SRA, following on from the PPI cap, to adequately protect consumers from excessive charges in claims management work relating to financial products and services. And the discussion paper sets out how we propose to carry out that duty. In that context, we have recognised that there is a legitimate market for claims management services, including those provided by law firms, but also that consumers can make claims directly to businesses for redress that may have missold to them, that are free to use statutory schemes against certain financial businesses, and that these claims do not involve a legal process and are designed to be directly accessible by claimants. You will no doubt be familiar, but just as a reminder, the SRA is a designated professional body under the Financial Services and Markets Act. This means we are able to regulate some claims management activities provided by law firms without the need for dual regulation. Alternatively, firms can be regulated by the Financial Conduct Authority to carry out these activities. Touching a bit more on that, the FCA is the largest regulator in this field. They have already consulted, set the ball rolling, and have consulted on proposed fee restrictions. They have been able to access data sets to model the impacts of their proposals. So as the discussion paper sets out, our starting point, and I really emphasise this is a starting point, because the process to make a claim is the same, regardless whether it's made by a consumer or a professional representative regulated by ourselves or by the Financial Conduct Authority. The process is the same. So our starting point is to test the FCA's proposals as a benchmark. Nothing is set in stone. We want to hear from everybody affected. In that context, we thought it was helpful at the webinar just to very briefly touch on the key aspects of the FCA's approach at the webinar, and so it's available as resources. We think this is important because we are saying this is a benchmark to start from. So just very briefly, the scope of the FCA's restrictions is any claim that is made free of charge, where there is a statutory redress scheme. And their data set shows that nearly all claims relate to packaged bank accounts, loans, savings and investments, or pensions. So that's the scope. The level of the cap reflects two elements. The value that they think that a claims management company service provides to the individual. And that value is defined in terms of the time and effort saved by using a professional service, and the consumer confidence that brings. Their modelling also takes into account that they want to maintain a viable market for claims management, professional help in claims management work. So that's another critical aspect. And finally, in terms of the level, it is set at a level to provide consumer protection for excessive charges. It's not designed as a fair fee or an economic fee. It is set at a level to protect from excessive charging. And just finally, on the FCA's approach, on the design, next slide, please. They have established a banding approach with charges set between 15 to 30% according to the level of redress. And the critical assumption that they have, well, it's not assumption, the critical point that they make here, and again, this plays back to their data set, is that costs are relatively flat across the different redress bands, and that therefore, in their view, charges are most excessive at the higher redress levels. The reason I wanted to set out the FCA's approach is because, as I said, we are using it as a benchmark. So it's important, I think, to understand the key assumptions that they've made. Right, I'm going to hand over to Liz now to focus on what our next steps are.
Okay, thanks very much, Emma. So as already outlined, the paper sets out some of our initial thoughts, and we are seeking views and evidence from stakeholders regarding its suitability as a benchmark. We're supporting this with a range of activities designed to help us engage with stakeholders and with you in different ways and build our evidence and understanding of the possible approaches we might take here. So there are a number of key considerations that we'll be looking to build evidence for, and we'll be discussing these with stakeholders in the coming months. The key areas that we have identified so far are the role solicitors play in helping people make a claim and the types of claim, whether or not this is different to a CMC or results in different outcomes, how law firms operate which may impact on sustainability as a result of fee restrictions, and are there unintended consequences, for example, on law firms that undertake reserve work in this area which will not be subject of the fee restriction? We are really interested in understanding what this looks like and looks like at the moment in terms of evidence in the work itself, and how it may result in different outcomes for consumers when a law firm is involved in pursuing and progressing a claim. How is this different to the service CMCs provide? Anecdotal evidence is not a good base for us to model a fee cap. We need evidence to support any contentions. So how are we going to go about exploring these considerations? Well, we want, through this discussion paper, to gather better information about those law firms that are involved in this kind of work and therefore caught by any fee restrictions or other obligations we might impose. So, for example, whether there is anything different about the profile of case types undertaken by law firms as compared to CMCs. That may result in a significantly different impact from fee restrictions, and how law firms and different segments of law firms operate, which may impact on their sustainability as a result of fee restrictions, and therefore the ability of consumers to access claims management services from law firms. This is where you have the opportunity to provide us with evidence about the impact on you. We have previously identified a sample of about 2,000 firms that may be carrying on claims management work. We surveyed these firms to try and obtain information about the claims management work being done in these areas, including their fee models and the work done for their clients. Unfortunately, the response was disappointing and it didn't give us enough data to really draw the kind of conclusions we need. Therefore, we hope that through this discussion paper, we'll get relevant information to inform options for consultation. We're also intending to carry out a survey with law firms to help us gather evidence. So please watch out for the survey in the autumn, as it will be one of the ways that you are able to tell us what you think and to provide evidence to inform the development of our proposals. We'll communicate this through our SRO update newsletter, our social media, and a range of other channels. But we'll be really pleased to hear any ideas you might have for targeting the survey to the correct firms. Please feel free to add any suggestions you might have into the webinar comments as well, so we can keep up to date with those. So what else are we doing? Well, we also want to reach out to consumers, as their perspective will be an equally important element of our evidence base. This will include using focus groups and other consumer research approaches to engage directly with members of the public And we'll also hold meetings with groups that represent consumers and their interests to get their views. In addition, we have little data about why consumers actually engage with services of a law firm for claims management activity. We want, therefore, to explore why there are different reasons why they might engage with CMC, and also, does a law firm offer a service that is significantly different to a CMC? If you have any suggestions as to how we should be taking this engagement forward, again, please add your comments to the webinar comments. So, as Emma said at the start of the webinar, a number of questions have been raised. Perhaps, Emma, we can look at some of those now.
Yeah, certainly. Sorry, not the computer. Hi, yes, I've been looking at the questions, Liz, and one that struck me, actually, we've been asked about whether we have evidence about the profile of claims picked up by law firms, but specifically if they've been rejected by the FSCS, and whether we think expertise beyond that to be expected from a member of the public is necessary to manage those sorts of claims.
Okay, it's a good question. I just, yeah, okay, I think we are engaging with the FSCS, so we do understand what the data is that they might hold about this. What I can say is that if what is being said is that law firms deal with more complicated matters, then we need evidence from the profession that this requires expert input. Of course, this will always depend on the nature of the case and the duty to act in the client's best interest. But again, we would really welcome your views and comments about this to help us formulate our proposals.
Okay, brilliant. So evidence is key. It's all about the evidence.
It is.
Another question that actually is cropping up quite a lot is a question about why the SRA is striving to align itself with the FCA.
Okay, thanks, Emma. Yeah, we've had quite a lot of questions about along these lines, haven't we? We've already outlined why we're using the FCA as a benchmark within the webinar, and that the discussion paper and this webinar is just the starting point for a full engagement programme. So no proposals have yet been set. It's all really to be formulated. However, unless we get evidence that shows that there is a difference in the market rather than just anecdotal responses, we may have no other rational path other than to adopt the same approach as the FSA. So again, please, we encourage you to engage with the discussion paper and let us have your views. I think we've just about had enough time to cover a few more questions. And one concerns the timing of the review, Emma, and if the SRA thinks this review is premature, given that there are a number of judicial review cases currently pending against the FSCS.
Okay, again, thanks. That's a really good question. Firstly, just make the point that the statutory duty has been in place for some time now. So in terms of delaying in response to pending judicial review cases, that's not an option for us. We cannot delay in performing our statutory duty. Reflecting on that question, actually, a couple of points in relation to that. If there are newer areas of claim that arise out of judicial review decisions, we probably would expect some of that work to fall outside of the fee restriction. This is because the rules we make will not recover reserved work. We are in a different position to the FCA in that regard. And just to be clear, and this plays back to another question that we've had, if a matter is litigated, the fee cap will still apply to the non-reserved elements of work in that matter. And so we would expect firms to record their time spent on non-reserved and reserved work appropriately. We do recognise this is a complication for law firms. And again, we are asking for feedback from law firms about what that means for them in response to our discussion paper.
Okay, thanks for that, Emma. And what about the timescales? What happens from here? Can you give us some kind of indication of what the next steps are?
Yeah, I mean, we set out an indicative timetable in the discussion document. The Act itself, in terms of the duty on us, does not actually set a specific date for us to make rules. Our discussion paper closes on the 29th of September, so it's a while yet. Liz, you outlined a number of activities of engagement that we're seeking to build evidence alongside the responses to the discussion paper. So we're hoping to bring all that together in terms of potential firm options towards the end of this year. Now, that means we would potentially need to do another consultation at the beginning of next year. So in terms of final decisions, and this is in the discussion paper, our sort of first indicative view on that would be to make final decisions towards in the summer 2022.
Okay, thanks ever so much, Emma. Is there anything else you'd like to add before we sort of wrap up the webinar?
I've not. There's no, I don't think we've seen any new questions coming through. So unless there are, just to reiterate, this is the beginning of the process. If we're happy to have engagement outside of this webinar with people. I've already got a number of meetings set up on that. So please, we're here to listen to any concerns that you may have and to take off proposals forward on the best basis possible. Okay, so thanks ever so much. It brings us to pretty much the end of the webinar. So Emma and I would like to thank you for attending. It's quite hard to sort of do the webinar and look at the questions at the same time, so I apologise if we haven't had the chance to answer your questions, but we will be looking through them all to see if there are things that we can cover off in future webinars and communications. As Emma said, we are really interested in what your views are on this and helping us formulate what happens next. So please do feel that you'd like to engage, or please do engage with the discussion paper. And finally, it would be great if you could click on the evaluation link below this video stream and let us know what you think. It's really quick to complete and it will help us to make sure we deliver content in the future that you'd like to see. So thanks very much again. Thank you.